Hello everyone, welcome to our first Instagram Live for 2025. I hope you all had a good December and January. My name is Safeda, you may call me Kay. I'm the founder and director of my own law firm, Safeda and Associates. And today I thought it would be a great idea to talk about customary marriages. In my practice, we specialize in antenuptial contracts, and so it is something that I come across frequently, and I notice that many people don't understand customary marriages and the legal implications thereof. There are a lot of misconceptions, there's a lack of education, so I thought today we would come on here and talk about customary marriages and antenuptial contracts. And I'll be joined by my co-host, Lisa Thomas. Lisa Thomas is an educator in the legal space. She educates candidate attorneys and junior attorneys. And we have these Instagram lives to educate not just candidate attorneys or junior attorneys, but everyone, including my followers, including my clients. The information that we will go through today is often something that a client would pay for. Okay, so this is very important information for you to have. Lisa has a lovely mentorship program. If you are a candidate attorney, you can join the mentorship program, Legal Empowerment Hub. You can search for them on Instagram. And if you'd like to be mentored, you can join that program as well. While we wait for Lisa to join, I just want to say hi to Tabile, who has joined us. Thank you so much, Tabile. And of course, if you have any questions, you're most welcome to pop that in the chat. We can have a discussion. We will be going through the legal requirements of a customary marriage, how to register it. We'll go through some misconceptions, and we'll go through some scenarios as well. Okay? Thank you to everyone who has joined us. And we will be posting this Instagram Live on YouTube, so watch out for that as well. And I think this is such an important topic for everyone who is engaged or planning to get married or in a relationship. I find people, they only want to know about it when it's time to get married. And I think it's very important to know about it before then. Always educate yourself as much as possible. And be prepared. It's better to be prepared than to make assumptions and to not know what is going on. Of course, you may DM me with your questions as well. Please do follow us on @Safeda Law. I have a website as well, www.safedalaw.co. You will find my business on Instagram, Facebook, LinkedIn. And I have a personal profile on LinkedIn, so please do follow us and stay tuned for more Instagram lives. Lisa and I have a few lined up, I think up until May. So we'll be hosting one every month, and I do post about it to let everybody know. So follow those pages if you're interested in watching these Instagram lives and being educated in the legal space. We're just waiting for my colleague to join, and I'm just waiting for everyone else to join as well. I'm just going to give it a few more minutes, just waiting for everyone to join. In the meantime, while we wait, let me grab a sip of water. If you have any questions, please put them in the comments. I'm just waiting for my colleague Lisa to join. And And while I'm waiting for her, I'll just go through some of the services that my law firm does. We do antenuptial contracts, we do company registrations and company secretarial work, we do conveyancing, we do general contracts, and we do wills and estate planning. If you're interested in any of those services, please pop me a message. I'll gladly have a consultation with you or give you a quote for the services as well. I'm just waiting for my colleague to join. She is here. I can see that she's joined. Asked Lisa to join. I've accepted her request. I am just waiting for Lisa to join. She will be joining us shortly. Hi, Razik. Thank you for joining. Yes, that's great. Thank you all for joining. I really appreciate it. Lisa, I have given an introduction to the topic as well, and I've introduced you, but if you want to introduce yourself, you may go ahead. We start off with a definition. So, what is a customary marriage? Okay, a customary marriage is one that is celebrated in terms of customary law, and these customary marriages are governed by the Recognition of Customary Marriages Act number 120 of 1998, which came into effect in 2000. Okay, so in this act, it defines customary law, and I'm going to read it to you as the customs and usages traditionally observed among the indigenous African people of South Africa, which form part of the culture of those people. So if you are a Zulu and you are celebrating your marriage in terms of Zulu customs, then you are getting married in terms of customary law. If you are Xhosa and you are getting married in terms of the Xhosa traditions, then you are getting married in terms of customary law. Okay? This act recognizes the legal validity of customary marriages. Okay? So as long as the requirements for a valid marriage has been met under the Recognition of Customary Marriages Act, then the marriage is considered to be valid and legally binding. Okay? So the way we usually do these Instagrams lives is that Lisa and I would ask each other questions and have a conversation about these topics. Because it's just me right now, and she has said that she's unable to join, and she's actually got load shedding right now, I will just be continuing this conversation on myself. So, what about customary marriages that have been entered into prior to this act? So, the Recognition of Customary Marriages Act expressly says that these marriages, as long as they've met the requirements for a valid customary marriage, then the marriage is valid and recognized. Okay, so it doesn't invalidate all the customary marriages that have been performed before the act came into effect. It recognizes that there were customary marriages before this act, and it actually says those marriages are also valid legal marriages in terms of the eyes of the law. I'm just trying to see if I can join Lisa from my side. Let's see. Okay, so of course, so if the marriages are valid, right, and they're valid if they meet the requirements under the Act, what are those requirements? So the Act expressly expressly says that both spouses must be over the age of 18. Both spouses need to consent.
Hi.
Hi.
Sorry. It turned that I had load shedding after all, so I switched to mobile data. I'm not sure if that was the problem.
Okay, okay. I've
Yeah, I'm
I've
here now.
gone through the definition of a customary marriage, and we are now
Hmm.
on the requirements for a customary marriage. Um,
Hmm.
I don't know if you quickly want to introduce yourself, and then we will continue with those requirements.
Okay. Take two. Okay, so my name is Lisa Thomas. I am known as the Law Mom on LinkedIn, helping CAs navigate career and also law graduates. So if you're not following me there for the last 4 years, you've missed out a lot. So I suggest you catch up. And yeah, Kay and I have been doing these lives since last year, and it's just a way for us to get each other out there, support each other, and of course, I'm also learning a lot from her, and this topic is no exception. So I'm pretty much going to take the back seats and allow her to talk to us about customary marriages, because I think it's, as we've discussed, it's an area that even amongst the relevant culture groups, there's a lot of ignorance. So I'm happy to be
Thank
here.
you. Thank you, Lisa. Thank you for joining us. Let's hope that your data doesn't run out and that everything goes
It's all
fine
good.
throughout life. So the requirements for a valid customary marriage. So the Act sets out specific requirements, and it says both spouses must be over the age of 18. Both spouses must consent to the marriage. And then interestingly, it says that the marriage must be negotiated and entered into in terms of customary law, or it must be celebrated in terms of customary law. The next requirement is that the couple must not be prohibited from marriage due to blood or affinity in terms of the customs. And then, if either spouse is under the age of 18, we need the consent of the parent or the legal guardian. And then it also goes on to say that a person married under customary law cannot also be married under civil law. So let's unpack those requirements, right? I think a lot of people, in a lot of customs, it usually is negotiations first, Lobola is paid, and then there's some sort of celebration or handing over of the bride. And a lot of clients come into my office and they assume that all of those requirements must be met. And the Act expressly says the marriage either needs to be negotiated or celebrated. So if the negotiations have happened first, then that is the date on which you are married from. If it's the other way around, that you have your celebration first, then you are married from the date of your celebration. And in most customs, you would have both the negotiations and the customs. Then it is whatever which one came first. If the negotiations came first, you are married from the date that the negotiations were concluded. And if your celebration came first, then you are married from the date of that celebration. There is this misconception that all of those requirements need to be met: the negotiations, Lobola paid, and the celebration, and that's not the case. Okay, you are actually legally and technically married when either one of those negotiations or the celebration has occurred. Okay, I also want to mention something about the Lobola here. A lot of people assume that when they have paid Lobola or even paid it in half, in part, that they are married because the Lobola has been paid. The Act actually does not state that at all. It actually doesn't even have Lobola as one of the requirements. Of course, Lobola is usually negotiated, and when all the negotiations are concluded and complete, then Thank you for joining. Then you are actually technically married. So I think there is this misconception. People think, oh, I paid Lobola, now I'm married. You're not actually married unless all the requirements under the Act, all the other requirements has been met. Okay? And then I want to talk about the other misconception that people seem to think that a customary marriage isn't a legal marriage. And in terms of the Act, of the Recognition of Customary Marriages Act, it is a valid marriage. It is recognized, and there are legal implications of this marriage, right? So customary marriages have been given the same status as civil marriages. Okay? Lisa, do you have any questions for me? Thank you to everyone who has joined. I see you, Fajani Attorneys. I see you, VK Inc. Attorneys. Thank you so much for joining. Lisa, we cannot hear you.
Yeah, so we know with the civil marriage, you got to go to Home Affairs and, get your certificate. So what are the requirements for registering a customary marriage?
Yes, that's a very good question. Again, a lot of people do not know that they need to register their customary marriage. The Act expressly says that you have 3 months from the date of your marriage to register your marriage at Home Affairs, or if you do not have a Home Affairs nearby, a traditional leader. Okay. And when you register your marriage, there's this particular form that needs to be filled out, a particular fee that needs to be paid. You need to have witnesses attending. You need to have a representative of the family. If there's a Lobola agreement, that needs to be taken, evidence of the marriage. So it is a lot that needs to be done, but it's very important that it gets done so that when you register your marriage, the person at Home Affairs can issue you with a marriage certificate. And that marriage certificate will serve as proof that you are married. Okay? And as you will see later on, and as we go through our discussion points and some of our scenarios, it's very important to have that marriage certificate. Okay? Lisa, are you there? Is everybody still
I'm here.
with me? You're with me. Okay. So when the act came into effect, I remember they gave all the existing customary marriages 12 months to register their customary marriage. The act came into effect in 2000. That date has long gone and passed for customary marriages that were entered into prior to the act. The minister has since published a notice in the Government Gazette last year in October stating that all those who have not yet registered their customary marriages can do so from the 1st of September 2024 to the 31st of August 2026. So the minister has extended this deadline in which to register your customary marriage. And I encourage each and every one of you, if you have not done so, please go and do so. So, Lisa, do you have a question for me there?
So what happens if maybe in ignorance or you don't have a Home Affairs office, neither a traditional leader, and you just don't register the marriage?
So, the Act says that even if you don't register this marriage, it's still a legal marriage and it will
Mm-hmm.
still be recognized. But in my personal opinion, I think it leaves room for doubt, right? Because then the marriage is open to dispute. Did you get married? Did you not get married? You have no proof that you're married. So are you really married?
Mm-hmm.
So the marriage certificate serves as proof that you are married. And it does come into play when you need to apply for a spousal visa or you need inheritance. For example, if you are the surviving spouse, the master's office will require a marriage certificate to prove that you are the surviving spouse and that you are entitled to a half share of the estate. So if you do not have this marriage certificate, then it becomes a process of proving this marriage through witnesses and affidavits, and it's a lot more paperwork involved to try and prove your marriage.
Mm-hmm.
Also, the Act says please register your marriage within three months of the date of your marriage. And I think it's a short period because you never know what happens. Your witnesses could pass on, your representatives could pass on, all the people that
Mm-hmm.
might be at the ceremony move on, they move to a different country. You don't know, right? So there is that short period of 3 months. In 3 months, they expect everybody to have registered their customary marriage, and that in those 3 months, there's no dispute as to whether or not you are married.
Mm-hmm. Okay.
So I think let's go through a typical scenario.
Mm-hmm. Okay. So scenario one, a couple enters a customary marriage without registration. Sipo and Tandi undergo a full customary wedding with the exchange of Lobola, but they don't register their marriage with Home Affairs. So, the legal implication, their marriage is still valid under the Recognition of Customary Marriages Act if all customary law requirements are met. However, failure to register it may cause complications in proving its existence, especially in inheritance.
Yeah, so that's exactly it, right? So if you don't register your marriage, provided that the marriage has met all the legal requirements under the Recognition of Customary Marriages Act, it is still a valid marriage, okay? And it's still recognized by the law. Just because you haven't registered doesn't impact the validity. It just makes it difficult later
Mm,
on to prove the marriage. And it makes it difficult in scenarios where it is a requirement to give a marriage certificate, and then as the spouse, you are not in possession of this marriage certificate.
mm,
So I think the next question that I get, and it's a big misconception, is that people come to me and go, okay, so I'm married in customary law, so what now? Okay, what are the legal consequences of that? And the default position when you get married in terms of customary law is that you are married in community of property, right?
mm,
That means that both spouses share in each other's assets and liabilities. So if the wife had a property before she got married, then the husband now is entitled to a half share of that property, even though he wasn't there when she bought it.
mm,
Okay, that's often the common scenario. Oh, but I bought this before I got married, so why does he get it? Well,
mm,
you're married in community of property. What's yours is mine, and vice
mm,
versa. So everything is completely shared. The assets and
mm,
liabilities of the husband and of the wife are joined together. And so we share in everything, okay? So be very careful if you've got assets already. Be mindful that your partner might be entitled to those assets as well, okay? So often then the question becomes, how do I prevent that? How do I prevent my spouse from getting my property? I don't want them to get my property. Um, and the way around that is to have an antenuptial contract, okay? So an antenuptial contract is a contract that is drafted by the notary, and it sets out the matrimonial property regime, which is to be married out of community of property with or without accrual. And it's to keep your assets separate from each other, especially those assets that you acquired before you got married. So you can state in the antenuptial contract, this house does not form part of our accrual or or in the case of if you're married out of community of property without accrual, that your estates are completely separate. Okay, you don't share in any assets or liabilities at all. Okay. The misconception, and I get this a lot of clients come to me, they've had their customary marriage, everything has been celebrated, and they don't realize that they are now married in community of property. They'll come into my office and they'll ask me to draft an antenuptial contract, and they want to be married out of community of property with accrual, for example. And I state, when did you have your customary marriage? And they go, 2 weeks ago, and it was nice. And they show me photos. And I say, look, if you've had your customary marriage already, then I cannot ethically register an antenuptial contract for you stating you are married out of community of property, because when you are married in terms of customary law, you are married in community of property. Okay, the default position is that you are married in community of property. If you wanted to be married out of community of property, then this antenuptial contract needed to be signed before the negotiations already. Before any negotiations, before any celebrations, before anything starts, sign the antenuptial contract. Go and see a notary, sign the antenuptial contract, and protect yourself in advance before you get to the stage where you are already legally married in terms of the recognition of Customary Marriages Act. Excuse me, let me grab some water. Thank you, Jazz and Freshy, for joining us, and Ismail. So let's move on to the next question, Lisa.
So I think the next one is, if someone is already married in terms of customary law and of course in community of property, how do you go about changing your matrimonial property regime?
Yes, unfortunately, once you're married in terms of customary law, you are married in community of property. And by the time you've had your customary marriage and the client has come into my office already, it's too late to sign an antenuptial contract. Then my advice is you need to apply to a high court to change your matrimonial property regime. And you need to get a court order that states that you can change your matrimonial property regime. And when you have that court order, then you can go see a notary and sign a postnuptial contract, which is then going to be registered at the deeds office. So it's a much longer process. There's no guarantee that the court will actually allow you to change your matrimonial property regime. It's up to their discretion, okay? There's a 50-50 chance that you might not actually get to change your matrimonial property regime. And it is very expensive. It costs about 30,000 Rand or more. Now let's just do a bit of a cost analysis here. Let's compare that to the cost of a notary consultation, which is usually around 1,000 to 2,000 Rand. It's much cheaper to go and see that notary in advance before you have your customary marriage, before your negotiations or celebration, whichever one is coming first. And then also, compare that to the cost of an antenuptial contract, which could be 5,000, 6,000 Rand. It's also much cheaper to sign the antenuptial contract before the negotiations or the celebration, compared to having to change your matrimonial property regime later on. It's costly, it's lengthy, there's risk involved. You're not sure if you will be granted a court order. And then on top of that, you have to pay the notary to do the postnuptial contract. So it's very expensive. I always tell my clients, if you're thinking about getting married, please, in your wedding budget, put in that that cost of the notary, the consultation, and the antenuptial contract. And I also think it's very important to talk to your future spouse about this. A lot of people are too afraid to bring it up. They don't want to bring up finances. They're so in love. He's not going to leave me. He's not going to cheat on me. You just don't know. I know, Lisa, you're smiling. You just don't know. You have no idea what the future brings. I mean, a lot, you just don't know. Your spouse could change and all of a sudden be a different person. 5 years down the line, all of a sudden, they're not interested in you. They like the neighbor next door. So these things actually really, really happen. So I think it's, if you can't even bring up this conversation of having an antenuptial contract, I just think maybe this is not the right relationship for you, because you need to be so open and so honest in your relationship and so transparent that it's okay for you to bring up a conversation like this. So, Lisa, we got a question here from Jazz. Let's read the question. If ever a couple got married through customary law, and this happened 28 years ago, approximately, and to date there's not proof that they got married customarily, what happens in such a case? Okay, so even the act expressly states that even if the marriage is not registered, right? Even if it happened before the marriage was entered into and concluded before the Recognition of Customary Marriages Act, it is still a valid marriage. All customary marriages now are valid, all of them, even the ones that were entered into before the act, right? They are all valid. And even if there is no proof that there was a wedding, there's no marriage certificate, that marriage is still valid under customary law, okay? And it's still valid in terms of our South African law, okay? I would recommend that this couple go and get their marriage registered. Like I said, the Minister of Home Affairs has extended the deadline for all the previous customary marriages that were concluded before the act to go ahead and have their marriage registered. So even if it's 28 years later, please go and get your marriage registered. Thank you, Jazz, for the question. So I think, Lisa, let's talk about the next scenario with Lebo and Sizwe.
So Lebo and Sizwe marry under customary law but do not sign an antenuptial contract. The
So
legal implication,
yeah, so
yeah.
I think the legal implication there is that provided they've met all the requirements under the Recognition of Customary Marriages Act, it's a valid marriage. And the default position is that they are married in community of property. If they did not sign an antenuptial contract before the negotiations and the celebrations, they are married in community of property, which means that they share equally in all the assets and liabilities. So if Lebo has a lot of debt, Sizwe is now liable for that debt. That's how it works when you're married in community of property. If they didn't want, excuse me, the scenario, then they needed to sign an antenuptial contract. Let me grab some water. So I think the next logical question then is, so how do we get an antenuptial contract, right? How do we go about getting this antenuptial contract? My recommendation is before the negotiations or any celebration is that you go and see a notary public, okay? Please do not go to an attorney. An attorney is not always a notary. I know you're smiling. And a notary is an attorney, okay? A notary is something extra, okay? I get a lot of attorneys coming to me. They've drafted an antenuptial contract, and now they want me to notarize it and register it at the deeds office. And of course, before I can do anything, I check the agreement, and sometimes it hasn't been drafted correctly. Please save yourself the trouble. Go straight to someone who is a notary. Don't go to someone who is only an attorney. Check that they are a notary. Okay, it's very important. In my mind, only notaries are supposed to specialize in antenuptial contracts and deal with antenuptial contracts. There's nothing worse than paying an attorney to do it, and then you have to pay a notary to fix it. It doesn't make sense, right? So go straight to the notary. The notary will draft, and you'll have a consultation. They'll draft an antenuptial contract. You'll then sign it, and then it needs to be registered at the deeds office 3 months from the date of signature. Okay, so I see Jay has another question. How does one prove that they got married if they never took photos or at least a letter from the husband to the wife's female? The couple in question is no longer together. So ideally, there should have been, besides photos, but there should be witnesses. There should have been witnesses. Usually the elders would negotiate, right? They have all the negotiations. And so there's a lot of elders who have witnessed these negotiations. That's why it's usually a large group of men together, all sitting and talking. Also, if there's a celebration, there should have been witnesses at the celebration, right? So there should be witnesses that can prove that there was a marriage. And often we ask the witnesses for affidavits to say, yes, we confirm that there was a marriage. It was on this date, this time. This is how the ceremony went, etc., etc. So if you can prove that there was a marriage to the witnesses, if there was a Lobola agreement, and of course, if there's photos, I know in your case you say there's no photos, then you can actually prove that there's a marriage. Okay. I hope that answers your question, Jazz. Thank you so much for your question. Lisa, let's move on to the next question, which we often get under the misconceptions about customary marriages. There are so many misconceptions, and I hope that this live will debunk some of those misconceptions. Lisa, we can't hear you.
Can you sign an antenuptial contract after a customary marriage?
Okay. We didn't hear you, so I'm just going to read the scenario. So, Teboho and Ayanda enter customary marriage in 2018 without an antenuptial contract. In 2023, Teboho starts a business and now wants to protect his assets, fearing financial risks. He and Ayanda decide that they want to change their marital property system to out of community property. Okay, so they entered into a customary marriage. Okay, their marriage has met all the requirements under customary law, under the Recognition of Customary Act. Then it is a valid customary marriage, and they are, because they did not sign an antenuptial contract, they are married in community property. Okay, if they want to change the matrimonial property regime, right, then they need to apply to court, to the High Court, for a court order to change their matrimonial property regime. Okay, it's not something that will automatically be granted. The court has a discretion to decide to grant it or not. Okay, there's only a 50% chance that you will succeed. Okay, and then if they are successful and they get granted this court order, then they may see a notary to sign a postnuptial contract, which will then be registered in the deeds office. So you are capable of changing your matrimonial property regime. Okay, the couple can change their mind later on. but the court will examine all the evidence and look into all the factors and circumstances. It's not a guarantee. It is also a very expensive process, about 30,000 Rand or more, and it can take a few months as well. So just bear that in mind. So let's move on to the next question. There's this misconception again that if the customary marriage is not registered, it is not a valid marriage. That is incorrect. Okay. Can you guys hear me? That is incorrect. Customary marriages are valid customary marriages, valid legal marriages in the eyes of the law. And even if it is not registered, it is still a legal valid marriage, okay? It's just better to have a marriage certificate because then you do not have to prove that you're married, okay? The marriage certificate is a much easier route. So let's look at a scenario. Jabu passes away, leaving his wife, Daneo, and their children behind. His family claims their customary marriage was not registered and that she is not entitled to inherit. This is a very typical scenario. This is the in-laws trying to say they didn't register their marriage, so she can't claim inheritance. False. Completely and absolutely false. Okay? Under the Recognition of Customary Marriages Act, provided that they met all the requirements for a valid marriage, then the marriage is legal and valid, okay? And they are married in community of property, and it doesn't matter that the marriage was not registered, okay? The Act expressly says even if the marriage is not registered, it's still a valid legal marriage. Because from this scenario, there's no signing of an antenuptial contract. They are married in community of property by default. And therefore, Daneo, the wife, is entitled to a half share of Jabu's estate upon his death. Okay? She will have to prove that she is the spouse because she does not have a marriage certificate. And this is exactly why the marriage certificate is so important, because the master's office always asks for the marriage certificate. So let's move on to the tricky bit. Let's move on to polygamous marriages. Okay. I just want to check if we have any questions. It's a pleasure, Jazz. Thank you, Leah, for joining us. So, what happens in the case of a polygamous marriage? So far, we've dealt with monogamous marriage, but in customary law, the husband is capable of taking a second wife, for example, right? So there are two different scenarios here. Let's deal with the scenario where the husband is married in terms of customary law, even if that was before the Recognition of Customary Marriages Act. And then he wants to enter into another marriage after the commencement of the Recognition of Customary Marriages Act. So in this scenario, the husband needs to go to court and he needs to have a written contract approved by the court regulating the matrimonial property regimes of both spouses. Okay? And if that contract is approved by the court, it must be registered at the deeds office. In the case that the first marriage is one where it is in community of property or with accrual, the court will order that the matrimonial property system of that marriage is dissolved and that there is an equitable distribution of all the assets, all the property. Okay? So that when this new contract takes into effect, we start again from zero, right? So that the property that the first wife is entitled to doesn't end up going to the second wife. So we can see from the act they're trying to protect the first wife and ensure that the first wife gets the property that she is entitled to, gets the assets, especially if she is married in a community of property. We can also see from the recognition of Customary Marriages Act that it's no longer a simple thing where the husband can simply enter into a polygamous marriage. He now needs to go to court to enter into a polygamous marriage and have that contract made a court order. Okay, the court needs to actually approve that written contract governing the matrimonial property regimes of both spouses. And the first wife needs to be joined to the proceedings. Okay, this is entirely new. I think so many people do not know about this at all. So it's operating very differently after the commencement of the recognition of Customary Marriages Act. Lisa, are you still with me? Okay. What happens in the case of a polygamous marriage and the contract was not approved by the court? So what the act says is it says any subsequent marriage is not null and void. It's a valid marriage, but it is one out of community of property. So when we talk about out of community of property, it means the two estates of the husband and the wife are not joined together. They are kept completely separately. Okay? What's hers is hers, what's his is his. They don't share anything. And so it ensures that the second wife cannot inherit anything from the husband at all. It's in my mind, when I read this act, it really is trying to protect the first wife. So let's look at the other scenario. What about polygamous marriages entered into before the recognition of Customary Marriages Act? Okay. So the recognition of Customary Marriages Act states these marriages would remain subject to customary law. Okay, and that's all it said. Then we had a new act. We had the Customary Marriages Amendment Act, Act number 1 of 2021, which came into effect on the 1st of June 2021. And this amendment changed that. It actually said that the spouses now have joint and equal rights of ownership, management, and control over the marital property. This Amendment Act provided for 3 different categories. Family property, which is property belonging to the whole family, which is owned and controlled for the best interest of the whole family, jointly and equally. Okay. Then there is house property. I'm sorry. The family property is jointly. Oh, sorry. Let me just start again. The family property belongs to the whole family, which is owned and controlled for the best interest of the whole family, jointly and equally by the husband and all his wives. So everybody shares in the family property. Okay. Then there is house property. House property is owned and controlled jointly and equally by the husband and the wife of that particular household. Okay, so there's family property everybody owns, there's house property, only the people in that house, the wife and the husband, own that property, and then there is personal property, which belongs to the spouse personally. Okay, so this is a new amendment. I think everybody's waiting to see how this amendment will be interpreted. I think it's very interesting where it makes room for all these different types of categories. It also leaves things open to dispute because now spouses are going to argue, well, what's family property? What's house property? What's personal property? So I think it's going to be very, very interesting. Lisa, what are your thoughts?
I think when we were just planning for this live, I spoke about the whole succession tangent. I think that's probably where it's going to probably come into more
Mm-hmm. Mm-hmm.
just dispute because I mean, whether there's a will or there's no will, families are they usually don't do the distribution thing very peacefully anyway. So I think that's where it's going to come into, especially with customary succession, where like the order in which they were married, it actually matters where there's no will, and you got to figure out, okay, which house comes first. Each wife has a different house. You got to look for the eldest male child in the house, the next eldest male child, and so I think that the cause for dispute there would definitely be more um, in the succession arena than in the marital arena. I think the so-called Western couples fight more about property, and they're likely to take those things to the court and want half and half and or not half and half. And so I think it'll be less about like the marital property, but more I think the disputes will arise in terms of um, the succession issue, because marital regimes in succession just, they are married to each other.
They are married to each other. You can't do the one without the other.
Yeah, yeah. I mean, very often the marital regime determines, it's like it's part of the calculation in terms of, okay,
Mm-hmm.
she gets half for 50% first, and then whatever's left goes to everybody else. And then if there's no will, then of course the calculations are different. But at least the way I sort of teach, I would teach estate or succession is that when you want to do the calculations, to figure out who gets what and how much, and it's usually the marital regime that's the starting point to figure out, um, who gets what and what's left, and then they get so much of what's left. And so I think it's definitely very interesting when it comes to customary law, like I said, because of the customary intestate succession is very complicated because of and if he has multiple wives, and like I said, each wife forms a different house. And so in order to go down the line of the houses, you'll have to know who got married, when he took which wife, when. So I think it definitely will play a role in the succession uh, debacle. And definitely with having more children and more wives, it definitely complicates everything.
Yeah, it is very complicated. And I think a lot of people are not familiar with these requirements and how it impacts their life. I mean, it only becomes apparent to them when someone passes on, oh, this is actually what it means. This is the situation that
Yeah,
so and so left us with now because of how they got married.
yeah. And I mean, you could have the situation where you mistakenly believed you were married, or you didn't know that your customary marriage was in community or property. And so when your spouse dies, you realize. And I think like most civil married couples do, they only realize when it's death or when it's divorce. Oh, so he or she gets half. It's like, yeah, well, that's too late.
Yeah.
So I think that's also a wake up call. And of course, if you thought you were married and maybe you just missed out one requirement and it turns out you were not married at all, and you're actually cohabiting for purposes of the law, then like that would certainly complicate it. But I think knowing now like the requirements and what to do to change the regime. And like you said, it's more cost effective to factor that in at the outset to say, right, we want community, we don't want community. And look at the wedding planning, look at the price of all those things, and just say, okay, we're going to go see a notary public and we're going to go sort this thing out, because when this man or this woman passes away, then, we don't want to be saddled with, okay, so we were actually mistaken under which regime we were married, or whether we were married at all. That's never a nice thing to find out when your spouse has passed away, or when it's time to divorce. You're like, oh, there's no need to divorce because you weren't actually married. Um, but yeah, I think we can definitely. It's one that's a very comprehensive topic. So I think we'll probably do another session, at least from the succession angle, intestate customary succession. Um, it's something that's very complicated to do. But of course, because marriages are recognized now, customary marriages, so the civil procedure, the rules of succession that we use for civil marriages to apply. So I think it makes more sense under the succession flag, because that's, as I said, that's usually where families tend to, have a bust up about the thing, because it's not so much about the marriage. The marriage is between the adults. They'll get married, they'll get divorced. Not so much about the assets, having to give the assets to children. But I think in the case of someone dying, and it's a customary marriage situation, definitely the way the assets will devolve and which wife gets what, and if it was polygamy, then of course, like I said, it's more complicated. So I think we could probably do a session on customary marriages and succession, especially intestate succession where there's no will, because then the whole thing about applying to court for that court order, um, to validate the new marriage will apply, because, like I said, we have to know the order in which they were married in order to figure out, where to look for the next, next of kin, or the eligible heirs. So yeah, I think
Yeah,
it's a very,
yeah, I
yeah,
think
it's a very interesting topic, and I think we need to make more effort to apply it. Now that our law has recognized customary marriages, we need to make more effort to see, okay, so how does it apply to succession? How does it apply to this area of law? Just to bring it in, because we have recognized it now. So then it means all our other civil laws, when it comes to at least family, and law of persons and things like that, then we just make the connection back to see, okay, those laws now also tie in. So what are the implications for customary law?
I th- I think I think it's a great idea. I do think perhaps we should first do the basics of
Succession.
succession. Yes,
Yeah.
before we can go through, especially when it comes to polygamous marriages, before we can go through customary marriages, because customary marriages are more advanced, and it's a lot more difficult to do the succession division like that. And it also, I always remember when I used to draw these diagrams, like,
I
yeah.
always tell students, just I don't know why the exams don't even have like the pictures, like, because some of us need pictures to learn. So whenever I teach on that, I say, look at the problem, the scenario, and now draw the stick figures and draw
Yes,
the lines and the family tree, and just connect everybody so that you have a visual of whose child and whose wife and which wife came first and all those things. Like, draw a picture, and then you know what's going for what. So definitely, definitely it requires succession requires pictures. Uh, but I mean, at the end of the day, we have to know. I think we have to know the basics. I agree. We have to know the basics of succession, and of course, then how it integrates into a customary or customary law family situation, where
Yes,
all the
yes,
rules, all the implications of marriage, death, birth, divorce, all those things will apply now, and we just got to try and integrate all of those and say, okay, how do they extend into a customary family situation?
yes, yes. I agree with you. I think going to the basics. I don't know how we can do images on Instagram. I'm just trying to think. I need to draw. So like, like I need to draw to explain it because it's very
I can
difficult.
barely, I can barely get people to join my own lives. Like I don't know what I'm just saying. So
Guys, let us know in the comments, like, what would you like to see next? What topic would
yeah.
you like? Would you like the estate planning topic? Would you like a session on customary marriages and estate planning? We'd love to hear your thoughts. We have
Mm,
to figure out how to draw images while doing a live. I don't know. I might have to hold a board or something
yeah.
behind me. I don't
I
know.
think I'll just hold the board, just draw it and hold it up.
I don't know how to do a presentation on Instagram Live. Yeah. I see Tabele. Thank you so much for your comment. She has said that the session has been very informative. I can't wait for the next one to see what topic you will tackle next. Yeah, we will have one every month. We look forward to seeing all of you. I do just want to wrap up. There's like one more question and one more scenario that I get all the time. So, last question. So, how do parties in customary marriages get divorced? I was speaking to someone the other day, and they spoke about a legal separation. You know, oh my spouse just left me. I don't see them anymore. We legally separated. And I asked, how were you married? And they said, no, we're married in terms of customary law. And I said, but in terms of whether you're married in terms of customary law or a civil marriage, both marriages are legal, valid marriages, and the only way is to get a divorce court order. You have to go to court and you have to get a divorce. There's none of this informal separation or this legal separation. Like, it's not
Mm,
recognized in our law. Okay, you have to go to court and get a court order.
mm,
I think people need to realize you are married until death or
mm.
divorce through a court order. You cannot just mutually
Yeah.
decide, oh, we're separating, oh, we're getting a divorce without a court order. You have to go to
Kay,
court
I
to
just
do that.
sorry, I just want to bring in something there.
Sure?
I encountered a similar question either when I was in practice or now or recently, where somebody was asking about because in the US there's the concept of judicial separation. So I was once asked that question whether our law recognizes separation. And the answer is no. So whether it's under civil marriage or customary marriage, South African law doesn't recognize a separation as a sort of legal status for both parties. So you're either married or you're divorced. Those
Yes.
are, and of course you can't get remarried without being properly divorced. So in this situation, like you're saying, if either party wants to remarry, and because the other one has gone away, maybe lost interest, haven't seen them in ages, you'd have to at least go and get an unopposed divorce if you
Mhm.
want, you as the person who's so-called left behind, you want to um, continue with your life and get married. So you can't just go off and say we separated, therefore, and it's customary marriage, so it's up in the air. So therefore, I can just go and get married to someone else. That will not be allowed. It'll be illegal. So you'd have to, and of course, for the sake of closure, you'd have to go and get an unopposed divorce in a civil court, get that court order, and then of course that now frees you to marry someone else. But in terms, judicial separation is not recognized in South African
No,
civil law.
no. I think the only other route around it is to have someone declared dead, right?
Yeah,
Because you can't be married to someone
yeah,
who's dead. So
drastic,
if they've
but I
been,
think it's 7 years.
yes, very
Is it
drastic.
7 years?
I can't remember. Is it 7 or 10 years? Like they've been gone for 7 or 10 years. But you've got to prove that you've tried to track this person. You've tried
Yeah,
to contact
yeah,
them. You've traced them, and no one can find this person. And it's also very difficult if you don't have remains of somebody, because usually then
yeah,
they assume, well, they're somewhere out there without remains.
yeah,
But
yeah,
it's a very remote possibility.
yeah. Well, it's there in theory, but I think
Yes.
to choose between the lesser of two drastic options, I think divorce is because you can do that unilaterally, um, fairly unilaterally. You don't need so much of proof and affidavits and tracing agents and that a proof, sort of a declaration of death will require. So um, don't separate and then think it's legal. I think you can marry again, at least under customary law. We don't recognize judicial separation. If you want to go so far as to declare that person dead, to say they are dead to me, it's up to you. But of course, a far easier option would be to go through and get an unopposed divorce in a court.
I also want to mention a point where there's these scenarios where, or a trend where people in customary marriages get divorced and then they get remarried to change the matrimonial property regime, um,
To the same
to
person.
the same person, to the same person. I just want to say, like, that should never happen. Firstly, in our courts, it should never happen. When you get divorced, you are telling the court there's a breakdown of the marriage, right? An
Yeah,
irretrievable breakdown of the marriage. And
yeah,
when you do that, get divorced, and then remarry later on, especially if it's very soon later on,
yeah,
it could
yeah,
be seen as perjury or contempt of court. You've lied in court. It's a very slippery slope.
yeah.
Rather apply to change a matrimonial property regime instead of divorcing only to remarry. Um,
Yeah, I think overall it's just whichever practitioner is advising that is unethical because it's an abuse of the process.
yes.
So I mean there's only one way to divorce in South Africa, that's to show irretrievable breakdown. So if you say that, then of course you are lying.
Mm.
And then if you get married again, then of course it just looks like this whole system is at your beck and call. And of course, the other scenario, even with civil marriages, is where they come to the divorce and they realize, oh my, he's going to get, or she's going to get the other half. I don't want that. So let's change the regime and then we'll get divorced because I don't
There's
want him or her to get the other half, you know?
there have been scenarios where clients want everything moved into a trust, because I do trust as well, and then they later on want to get a divorce so that the spouse cannot get access to any of the assets in the trust. And there was a court case recently where the court actually pierced the veil of the trust and said,
Mm,
no, you did this with the intention to hide these assets
yeah.
from your wife. She will get half of those
Yeah.
assets in the trust.
Yeah. You will actually lose out in the long run because the courts will recognize your lawyer might you might get the papers through, you might get the order granted. It might seem like you won, but you will lose out in the long run because the courts will most often recognize it as an abuse of process. So probably going to get a bigger cost order, and it's going to become part of the judgment that you deliberately did this to hide assets from your spouse. And of course, that is not what the system, that's not what community of property is about. Okay, so if you didn't want to share, then you needed to say it up front. But if you're using other legal mechanisms in a marriage, in a divorce situation, to hide or to conceal or to preserve assets for yourself, when according to your marital regime you are supposed to share, then the court's going to look at that very, very unfavorably. And of course, your lawyer will end up looking bad um,
Yes.
at the end of the
Yes.
day, and you will get probably a very very um, strict cost order against you, which means you'll have to reimburse the other party for a lot of their legal costs because of your illegal conduct. You basically behaved in an illegal way, even though you might have said, no, it's loophole and this and that. But the courts don't look at that kind of thing favorably. Again, you rather change it. You rather change it, or you rather change your matrimonial property regime. Just do it the legal way and then maybe wait a bit and then divorce.
Yeah.
Don't make it so obvious.
I think it was strange in the first place that they were able to move the assets to the trust, because if you're, especially with property, if you're disposing of property and you're married in community of property, you need the consent of both spouses. You cannot just
Yeah,
transfer it to a trust without
yeah,
the consent of the other spouse.
yeah,
So I think it was done in a very fraudulent manner to secretly take everything away from her. And I think the court actually made a good decision for her. Um,
yeah.
it's interesting how people try to worm their way out of making sure that the spouse doesn't get any assets. It's interesting when I read these scenarios and you think, gee whiz, who does that? But okay, it happens. It really, really does
Yeah,
happen.
and I mean, their lawyers are actually giving them the reasons to believe that it's possible, which is why from our end as well, we have to make sure that the client is not calling the shots. You still have to direct the thing. And if your lawyer is giving you the impetus to do all these crooked things, then of course you also blame a bit on the advice that they're getting, rather than the people themselves, because obviously the lawyer is telling them, you can do this, you can do that, you can exploit this loophole, that loophole. So I think our practitioners also have to bear the blame. But yeah, look, whether it's customary or civil, you better decide quickly on your regime, because it's going to affect you in the case of a divorce, and it's going to affect your surviving spouse in the case of your death. So you better get that right and make sure there are no assumptions, and um, get all those affairs in order, at least before you get married or before you die, just to make sure that has to, whatever has to be distributed from your estate is, whether it's a divorce 50-50 or it's via a will, that, it's done according to what you intended for your marriage, from the outset.
Thank you, Lisa. Thank you so much for joining me. Thank you to everyone who joined us. Thank you to everyone who participated in the discussion. Thank you for all the questions that we had. I know we've gone over a little bit, but it's okay. This was a very interesting topic, and I think that not enough people are talking about it because it does affect all of us. All of us generally get married, and all of us generally, everybody dies at some point. So it does affect everybody. I hope that we see you all in the next Instagram Live. Lisa and I will do a discussion about what to talk about next. It will probably be the basics of succession law. If you're interested, please let me know. Give me a thumbs up or send me a DM and say, you know what, I'm unclear about this topic. Could you talk about this topic? We'd
Yeah.
love to hear your thoughts. Um, and we wish you, I'm so glad that your data managed to hold out, Lisa, that we managed to do the Instagram live. I wish everyone a very good weekend, even though I know we're all suffering with load shedding. Um, but yeah, have a good weekend. Take care. We chat soon. Thank you.